Hey, Brian Parker here. Today is these two very important letters, one of which was so important it caused the Indiana Court of Appeals to overturn a district court case just based on two letters. So let's take a look at those letters and how and why they're important for you. The case is Rockey versus Med1 Solutions, and what was happening is Med1 is a debt collector for a hospital debt that the plaintiff incurred and was harassed for the debt. Med1 sent 5 collection letters to the plaintiff, Miss Rockey, Lydia Rockey, and all the letters went to a former residence of hers that was owned by her ex-husband. I guess they were still doing okay because she was also his attorney, which Med1 did not know. But they kept saying the letters to the former residence. You know, you go through a divorce, there's a former residence. And her letter said that her ex-husband created for her, but she signed and sent, "I dispute, I'm refusing to pay the debt you're attempting to collect from me." So that's a common letter that you send for cease and desist. That may be part of a validation letter, and we'll get into that. But that's the cease and desist, meaning cease and desist. Once they receive that letter, and remember, you always send it certified, return receipt requested, so you can prove they received it. Once that letter is received, you're not allowed to contact the person again. Whereas if you send a validation and dispute letter, they are only allowed to contact you once they've properly validated in response to your letter. So we're going to look at those distinctions, and we'll look at that, how the Indiana Court of Appeals looked at that. So let me put up what the actual rule under the FDCPA for cease and desist letters. Okay? So if you look at C, the ceasing communication, the debt collector shall, so whenever you see the word shall in a statute or a law, it means there's no alternative. It's not a suggestion. If you see the word may, you can, that's wiggle room. If you didn't do something, it says you may do this, you can say, well, it's not a shall. A shall is you must, a may is maybe. So the debt collector shall not communicate further with the consumer with respect to such debt. So the important words there are, if a consumer notifies a debt collector in writing that the consumer refuses to pay the debt, she had written, if you recall, "I dispute and I'm refusing to pay the debt you're attempting to collect from me." It's a very plain meaning, good way to write. If the consumer refuses to pay the debt or the consumer wishes the debt collector to cease further communication with the consumer, again, the debt collector shall not communicate with the consumer further with respect to such debt. So if such a notice from the consumer is made by mail, the law requires, the notification shall be complete upon receipt. So you always send these type of letters, return receipt requested. So they have to sign for it. There's other ways to do that, but that's a simple way if you're not going to FedEx. It costs you about $5 and they have to sign for it. Once you get that green card back, that's gold. I've had plenty of cases where they claim not to receive something, and here I am with the green card. It'll save you. So here's where things went wrong for MedPay. So whenever you send a letter to a debt collector, whether it's a cease and desist letter, a refuse to pay, or a validation, they mark it in their records. They're very conscientious, believe it or not, about that, because the FDCPA, or the violation thereof, is very important to them. They really are, that is a heavily regulated statute, heavily regulating the debt collector, not the debtor, and we can get into that in another video. But they are required to do things, and they worry about that. So everything goes in the file, and I commonly will seek requests to produce of their files. So if they're telling me one thing, but the files say another, now we've got something. But they do it to protect themselves. And in this case, for some reason, the senior attorney at MedPay and their compliance officer was the one that formulated the receipt of the letter from Miss Rockey and put it into the system. And he looked at it and he perceived it as not as a refusal to pay, but as a validation letter. We're going to talk about that distinction. The cease and desist letter, again, requires you never contact that person again. The validation letter says you shall not contact the person until you validate, and then you can contact. So he looked at the letter and says, this is a validation letter, and put it in the system as a validation letter. Therefore, anybody working on this file looked at it and said, oh, we validated, I can keep sending the letters. And they did. They misread that letter as a dispute and validation letter and continued to contact her after the cease and desist letter and kept calling her. So let me just show you what a 1692 validation request statute looks like. And I'm going to show it very quickly, but the real section I want to emphasize. So here's the 1692 validation section. And let's go to 1692GB. Sorry, stay with me. And you can see the debt collector shall cease. Remember, shall means not a may, not a suggestion. The law places great consequences on the word shall. That's a direct order. So if you ignore that, you are automatically violating whatever statute that requires you to do something that you've ignored. So the debt collector shall cease collection of the debt or any disputed portion thereof until the debt collector obtains verification of the debt or the name and address of the original creditor and copy of such verification or judgment, and it is mailed to the consumer by the debt collector. So in other words, you can't contact the consumer until you properly validated, then you can contact. So the difference between 1692C, which is the cease and desist, and 1692 is G, is that you never can contact the person, with some limited exceptions, once you received a refusal to pay letter. But they categorized it as a validation letter in their files, so they went on collecting. So we've looked at the important distinction. They looked at it as a validation letter. The plaintiff in the case she filed, Miss Rockey, said it was a refusal to pay and cease and desist. So she filed a lawsuit claiming they had sent collection letters to the wrong address. She no longer lived with her ex-husband, obviously, who was also her attorney. And also they had continued to contact her after she properly sent them a cease and desist letter under 1692C. In a court, it was a federal district court case in Indiana. Med 1 had two defenses. You always have defenses. One, they had a Bonafide error defense. So the Bonafide error rule, briefly, is, yeah, even if we violated the law, we've created such maintenance of procedures and tripwires that even if the thing happened, if you can show you set up reasonable procedures for it not to happen, and then it did, you can't be held liable under the Bonafide error rule. And then number two, they argued no violation occurred because the letter was sent to the plaintiff's attorney. So 1692C also talks about if the debt collector is aware that the person's represented by an attorney, you are not allowed to contact the debtor anymore. It's a violation. So they turned that around on Miss Rockey and said, hey, we sent it to your attorney. Well, the thing is, they did not know that that was her attorney until later on in the case, later on after depositions and such. So the federal district court obviously went Miss Rockey's way. No, they didn't. The Indiana district court went the way of Med 1 and said, sorry, the Bonafide error rule doesn't apply here. They did everything correctly. They sent to your attorney. So she filed with the Indiana Court of Appeals, a federal district court, and that case is Lydia Rockey versus Med 1 Solutions LLC, Court of Appeals case number 22A-CT-2159. So here's how the Court of Appeals looked at this and held. First, it held that Med 1 did violate the FDCPA because the collection letter was addressed to the plaintiff and not her attorney. It's an important distinction. If they thought they were sending it to her attorney, as they alleged in their lawsuit defense at the lower level, then it would have been sent to her attorney. The fact that the attorney happened to live at the address was irrelevant since Med 1 didn't know this. True. Second, and most importantly for our purposes, the court distinguished between mistakes of fact and mistakes of law. Okay, under the Bonafide error rule, if you make a mistake after creating all these procedures in an intense approach to stop any violations, it's fair and common sense to go, hey, look, they did try, it still happened anyway, we're not gonna hold them accountable. So defendants, when you're suing defendants, when I sue debt collectors all the time, they always say the Bonafide error rule. Yeah, it may have happened, we don't admit anything, but we had these great procedures set up for it not to happen, therefore we're not liable. So the court said, yeah, but that only protects factual errors. And that is true. In a Supreme Court case out of the Sixth Circuit, Germain versus Carlisle, the court held that mistakes of fact are not protected by the Bonafide error rule, only mistakes of law. So in this case, the Court of Appeals used Indiana case law and the Germain case to say this was not covered by the Bonafide error rule because the Indiana attorney that was handling this letter, for some reason, the senior counsel got involved here. He looked at the letter and categorized it as a validation letter, which later allows them to contact Miss Rockey, which they did, even though she says, I refuse to pay a cease and desist. So that, at first glance, appears to be a factual error, but it isn't. He, the attorney, and by the way, he's an attorney, had two choices: categorize as a validation, 1692G, or categorize it as cease and desist, 1692C. Those are both legal choices, all right? So he made the wrong choice of law. And the Indiana court saw what the Indiana district court, the appeals court saw what the district court for some reason didn't see, that was a mistake of law. Mistake of law aren't protected by the Bonafide error rule. So that is not a defense to screwing up and continuing to contact Miss Rockey. And because they categorized it wrong, they are liable, and she won her appeal. So how does that help you here? Well, first of all, I'm going to attach to this video at killdebt.com a letter, a great cease and desist letter for you, but I'll also attach one of my famous validation request letters. But the important distinction for you is the important distinction that the Indiana Supreme Court has made. And that is how you categorize these things, whether it is at the beginning or at the end, so the debt collector categorizes is very important. So it's all in the language. Remember we talked about shall versus may? Well, she said refusal to pay, and that is, let's look at the 1692C again, Shazam, and that is, again, C. If a consumer notifies a debt collector in writing that the consumer refuses to pay, here's what she said: I dispute and am refusing to pay the debt you're attempting to collect. She is categorized as a cease and desist letter. So that's what she did. So she did everything right, but a mistake of law was made. So how that benefits you, be careful with your language. My letters will be created for you on killdebt.com, but I'll go one step further, as I always do. Parker GPT has all 11 to 1200 checklists, cheat sheets, motions, answers, complaints. Everything I've done in my 30 years is embedded in Parker GPT, as these letters will be. So you can either download the Word templates with this video or just go straight to Parker GPT and it does all the work for you. I hope I've done some of the work for you in showing you words matter. That distinction that the federal courts make are yours to make too. So make sure you watch out when you send either a cease and desist or a validation letter, because if you don't make that distinction clear, the courts won't see it either. But in this case, the courts did see it, and I want it to make it easier for you to send and write the proper letters. I hope the video helped explain a recent case from the Indiana Court of Appeals. Thank you.